presumption. If they don't rebut your presumption, which means they don't respond line by line, they haven't rebutted your presumption. And when I talk about the Facebook group again, there's case laws that y'all can quote to pretty much support Rule 301 to make your case stronger. I'll include those later, but I don't want to put too much information here, because the main part I want y'all to understand is Rule 301 is your backing when they don't reply line by line to your affidavit. So that's a violation if they don't reply line by line. Federal Rules of Evidence, Rule 301. All right, Rule 601, competency to testify in general. So every person is competent to be a witness unless these rules provided otherwise. In a civil case, state law governs witnesses' competency regarding a claim or defense for which state law supplies a rule of decision. Basically, Rule 601, what it is saying, just in layman's terms, is that you have to be competent to testify, which means like you're a person. This is why corporations, debt collectors, CRAs, they are not competent to testify. This is why if you're suing them or they're suing you, they have to hire attorneys because they're not competent to testify. So when you're filing your cases, it's up to y'all to point that out. You want to point out as much as you can. Rule 601, competency to testify. This is why when you're suing when, like, let's say a debt collector is suing you. A debt collector was suing one of my clients. Basically what we did, besides FDCPA laws, we called them out. Rule 601, they weren't even competent to testify. So based off of the fact that they weren't competent to testify, unless they could testify under the penalty of perjury that they're competent to testify, the case needed to be thrown out. So we put out that motion to dismiss, the case got dismissed. So it's up to you to understand these things. You don't need attorneys to represent you. I'm not saying don't have an attorney to represent you, but it's important to understand, the process as well. So Rule 601, remember Rule 601 is competency to testify. These corporations, these CRAs, they are not competent to testify. If they happen to sue you, they sue your clients, remember they're not competent to testify, they're going to hire an attorney. And when they hire an attorney, that attorney doesn't have firsthand knowledge. That's going to get into Rule 602, which we're going to talk about. So Rule 602 is the need for personal knowledge. So it says a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter, right? So helping my client get her case dismissed as well. We include a Rule 602 as well. The fact that attorneys don't have firsthand knowledge in any case you're going to be in. Let's say it's you apply for a credit card. You have a credit card account. You're suing the company. They hire an attorney. The attorney was not there at the time that you